Okay everyone, welcome back to Barry McBarrington's class on copyright and Creative Commons. Today I'm going to go over some stuff about copyright law and I promise it's going to be fun. Sir, can you please stop making copyright fun? Never. Oh, sorry there buddy. Get back up on your chair. Thanks sir. Now, what is the purpose of copyright? Copyright was born with the Statute of Anne back in some century long ago. In the before time, there was the Licensing of Press Act 1662. Authors were not really fans and campaigned against this, and eventually it was repealed. Do you know what repealed means? Yeah, it was thrown out like garbage. Yeah, close enough. But what's this got to do with the purpose of copyright, sir? Kids these days. Fine, cutting to the chase. The Statute of Anne has another really cool name. It is an act for the encouragement of learning by vesting the copies of printed books in the authors or purchasers of copies during the times therein mentioned. Really catchy. Good title. Yeah, I think that's way better than the Statute of Anne. Yeah, I know, right? Totally. So there you have it. The birth of the copyright was about encouraging learning. People are encouraged to create stuff because they own the copyright in their stuff in the first instance. Why do you have that stick? It'll become relevant later. But is that true today? Does copyright encourage people to create more things? Well, in my opinion, creators are gonna create. Ever since we started smearing mud on the wall of caves, that's been true. We like to create stuff. It's just human nature. There are those who feel copyright is all about ensuring the profits, though, of mega corporations, like Disney. What's your opinion, sir? Oh, I'm very glad that you asked that. I feel copyright recognizes the labor that goes into creating stuff, which can be considerable, and often occurs without any financial benefit until after the thing's created. I mean, you take a novel, it takes years to make, and you don't see anything for it, normally, until after it's created and published, if you get it published. Yes, something like that. Okay, so I think I can see that people might view copyright in different ways. But what things can be copyrighted? Yes sir. You should take that helmet off, it's really hard to hear you. It doesn't come off, sir. Okay, but you did a good segue into my next topic. Good job. Have a star. Thanks, sir. Now, the great and noble copyright protects much, but not all things. Namely, it protects the expression of an idea. What does that mean, sir? Well, that means you have a cool idea for a story, don't go telling people until you've written it down. Once something is expressed in words, paint, wood, film, something that is relatively permanent, it gains copyright protection. Another thing that is not protected by copyright is facts. Facts. Not facts. Facts. The airspeed velocity of an unladen swallow is a fact. There is no copyright there. But sir, you didn't say what the velocity was. You just quoted Monty Python and the Holy Grail. You make an interesting point. Context is important. In copyright, so much depends on the specific circumstances of the use. I did not mimic the film in at all. Not one bit. Not in the delivery of the line. I was not quoting the movie in any way. Maybe Barry McBarrington didn't, but surely the scriptwriter did. I knew it was from the film, so that means the scriptwriter did. Look, this is not the right room for an argument. Moving on. I think you did. Shh. Bonk. On with the lesson. You can say copyright does not protect ideas. And you can say it doesn't protect facts. Also, you can say it doesn't protect data. But that is not always the whole truth. Copyright is never black and white. There's at least 50 shades of grey in between. And there are other ways to protect things. There are trademarks, registered designs, and patents. They protect things in different ways. These are the other types of IP that are protected in law. Patents protect the rights of inventors, preventing their ideas for a protecting their ideas for a set time so they can realize their invention. Prevents others from using it until they make the money. Cool, eh? A trademark identifies the goods and services of a business and prevents others from using that brand and protects the integrity of the brand. Like Nike knockoffs. That's bad. Don't knock off Nike stuff, especially if it's a Michael Jordan, because his shoes are really cool. Yeah, I really like them. I know, right? I play basketball. I play basketball. Oh, cool. We should hang out later. Shh. Okay, cool. And a registered design protects the unique appearance of an object. It stops people from making similar objects. Okay, you got it? So if you put it all together, let's pretend some smarty pants invented time travel. The copyright would be protecting the published research paper. They had to prove they invented time travel and had to publish in a Q1 journal. You know what I'm saying? Yeah, I know what you're saying. And then the patent would protect the formula, the theory, the thing that actually makes time travel possible. And then the registered design would protect the fancy case they put in. Let's pretend they put it in a phone booth that was blue. No, he's quoting Doctor Who. I didn't quote them, I just referred to them. That's okay. Oh, okay. And then, to top it all off, they could give it a name. Like the Wayback Machine. I think that's taken, sir. Nobody asked you. Now, that is a simple explanation. There's more to it. Maybe some grey. I talked about grey just a second ago. But let's not go too deep. Any questions? How does one person generally get copyright protection for their work, sir? I already said that. No, you didn't. Like totally did. No way, Jose. Look, I said once it is expressed in words, paint, wood, film, or something that is relatively permanent, it gets copyright protection. That's it. That's when copyright kicks in. Deal with it. When does it kick out then? Copyright expires at different times, depending on what it is. The most common length is 70 years after the death of the author. But let's talk about the public domain. What is it? Well, some people confuse the public domain and things that are just like publicly accessible. Just the things out there that you can see. That's not it, okay? The public domain is a term for things not protected by copyright. What does that mean? Well, 1984 by George Orwell is now in the public domain. That means anyone can copy, adapt, reuse it without permission from the creator. All the things that were protecting that work under copyright law no longer apply. Is this where you're going to say there is some grey areas and it depends on the situation, sir? Look, I could, but I can't be bothered, so let's move on. We've got one section left, and let's cover it. Now, what was it? What was the last section? You the teacher? Should you tell us? That's right, Barry McBarrington, teacher. The last section. Oh, yeah. Exceptions and limitations to copyright. Right. Copy that, sir. Huh? What? Huh? Oh, no. So, exceptions. Now, I'm going to talk about the Australian Copyright Act because that's what I know. Deal with it. In Australia, the Act is full of exceptions, and this goes back to the purpose of copyright. Another way to look at the purpose is to say it's a balancing act between creators and the users. Creators get a bunch of rights. In exchange, users get a bunch of exceptions. Sounds pretty good, right? Yeah, that's pretty good. Yeah, I think so. Yeah, I like that. Librarians have an exception to preserve works, for example, and they can copy works and provide it to their library users. Under, certain situations, there's limitations, there's grey areas, but there's an exception in there that helps them do that work. Okay? Okay. Now, for educators, they got some exceptions too. They can perform the works in class. They can copy portions of work under a statutory license. They do stuff. They got stuff as well because teaching is important. Education is important. right? That's what we're all here for today. Now, everyone in Australia gets the fair dealings. They are for the purposes of research and study, or for patire? That's not patire, that's not a word. I think I put two words together there. Parody and satire, and reporting the news, and for criticism and review. We don't get a general fair use thing. It's not a thing. You'll see people talk about it on the interwebs. I covered this in the last session. We don't do it, okay? Cool. That's unfair, sir. I know, so unfair, right? But we got a lot of exceptions in our Copyright Act, and we kind of make do. It'll do for now, and I've only touched on a few of them. So just deal. Now, there are some limitations of copyright. As a rule, only the copyright holder can bring action against a breach. If you make an illegal copy of Doctor Strange 2, only Disney can slap you in the face. Slap you with a cease and desist. Or on the wrist. Or sue you. The police aren't going to chase you down for posting a Star Wars meme online. Ever. And while in Australia it is technically a copyright infringement, it is unlikely Disney will hunt you down either for posting a Star Wars meme, okay? Copyright law and protection is all well and good, but there are times when it's just not worth enforcing. Like the public backlash of a company. Like when a public backlash against a company. This isn't worded very well in the script. I'm going to give it another go. Bear with me. Like the public backlash a company gets when taking down a fan-made stuff on YouTube. Nintendo, I am looking at you. That's right, Nintendo. Don't think we don't know what you're doing. Here endeth my lesson.